Well, let's go to the phones and let's
do
see
it.
what other questions we've got for. We're going to toss them to Meg.
Sounds good.
We've got our first caller, Shakeen from Dry Branch tonight. Hi, Shakeen. Jean, I'm sorry. Jean.
Jane, yes.
Got to get this earpiece taken care of. Jean, you still holding for us?
Yes.
Hi, what is your question for us tonight?
I'm the executor of my brother's estate, and his wife of 3 months has not come forward for her third of the estate. How long do I have to keep her third in the estate account? How long does she got till she can come forward and get her share? And it's not that she don't know she's got it.
Yeah, that's a good question.
That is a good question. Generally, an estate needs to be open for at least 6 months before the assets can be distributed out of that estate. And part of the reason for that is because the first duty of the executor is to make sure that all of the debts that the estate might owe, whether it's a medical bill or maybe even a credit card bill or secured debt like a mortgage on the property, to make sure all those debts are paid. So that has to happen first, but then the executor can go about distributing assets to the beneficiaries of that will or the beneficiaries of that estate. In this case, for that spouse, if she doesn't come forward, then there's a procedure in which those funds could be deposited with the probate court, and then eventually that person would just have to come forward to the probate court to receive their inheritance eventually.
So, just got some time there, and
Yeah,
have to be patient.
a little bit of time, a little bit of patience is always going to be important when you're dealing with the court system, because nothing happens overnight.
Let's assume that, for example, she didn't say this happened, but if the wife decides she wants to contest the will for whatever reason, but what are other reasons somebody can contest a will?
So generally, if somebody is contesting a will, it's because they think that that person didn't have the capacity to sign it, whatever that might mean. So they maybe had dementia, Alzheimer's, and they're questioning whether they even understood that they were signing a will, or they're questioning whether a family member or somebody might have pressured them, and so they were under duress when they signed that will. And so that would be a reason why you would contest the validity of the will, and that would be done through the probate court, and you would have to bring forth evidence to show that that person, was not in their right state of mind when they were signing that document.
So you don't generally object to or contest that, I got the silverware, I wanted the television.
Right.
It's more of a general, was that person competent to execute a will?
Correct, yeah. So that's what they're looking for, testamentary capacity of the, what we call testator, the person who signed that will. Just because you're mad that you didn't get what you wanted or didn't feel like it was fair, those aren't really grounds to contest a will.
And that issue, I'm sorry,
Good.
is decided in the probate court?
Yes, it's first decided with the probate court, with your probate judge in whatever county that estate is probated in. And then if there is an appeal, that then actually goes to the Superior Court in that same county. So you're not moving all the way up to the Georgia Supreme Court right away. You've kind of got to start right back over in Superior Court if you go that route.
And the venue is where the testator lived at the time of death?
Generally speaking, where they lived when they died. There are some exceptions to that, but that's generally where you're probating it.
Another call.